Prince Harry just stood up against two of the most powerful tech companies in the world, YouTube and Instagram, in a courtroom battle that could reshape social media forever. But here's the twist. The companies say they did nothing wrong, and if they win, nothing changes. So who's telling the truth? This isn't royal gossip. This is a fight over the future of the internet. Over the next 24 minutes, I'm going to take you inside a landmark courtroom battle where bereaved families are demanding answers, where billion-dollar corporations are defending their business models, and where one question echoes through every testimony. Could this change everything, or will it all come down to a 27-word law written in 1996? This is the story of David versus Goliath in the digital age, and it's happening right now. Before we go further, let me be clear. The companies named in this lawsuit, Meta, which owns Instagram, and Google, which owns YouTube, deny all allegations. They maintain they've implemented significant safety features and have done nothing wrong. This trial will determine whether those efforts were enough. What I'm about to share includes allegations made by the families, defenses raised by the companies, and expert analysis. This is not a verdict. It's the story of a trial that could change the internet. The courtroom, January 2025, a federal courthouse in Oakland, California. Inside a quiet courtroom, something unprecedented is happening. On one side, billion-dollar corporations with unlimited legal firepower. On the other, parents carrying photos of children who never came home. Outside, protesters hold photographs and signs reading, "Protect our kids." This isn't just another lawsuit. This is a consolidated federal case involving families from across America, Canada, and the United Kingdom. One of the largest coordinated legal actions against social media companies to date. But the real battle isn't just emotional, it's legal, and it hinges on a 27-word law written in 1996 that has protected tech companies for nearly 3 decades. The families aren't claiming these platforms accidentally caused harm. They're arguing something far more specific, that Instagram and YouTube were deliberately designed using addictive features that the companies knew, or should have known, could harm young users' mental health. Let me be precise about what they're alleging, that features like infinite scroll, push notifications, and algorithmic recommendations were designed to maximize user engagement without adequate consideration for mental health impacts. That internal company research showed potential risks to young users, that the platforms failed to implement adequate safeguards despite this knowledge. That recommendation algorithms promoted harmful content to vulnerable teens. The legal term? Product liability. The same type of case you'd bring against a manufacturer who knowingly sold defective products. But here's where it gets complicated. Can you really compare a social media platform to a physical product? The companies argue no. The families argue yes. That's what this trial will determine. Let me introduce you to the key players. The families are represented by the Social Media Victims Law Center and other legal teams. These parents allege their children died by suicide, from eating disorders, self-harm, or dangerous online challenges, and that social media platforms played a contributing role. Meta, which owns Facebook and Instagram, is represented by elite legal teams arguing they've done nothing wrong. Their position? They've introduced teen accounts with built-in protections, parental supervision tools, content warnings, and extensive safety features. They deny their platforms are defectively designed. Google, which owns YouTube, is similarly defended, arguing they're a platform that provides tools for parents, implements age restrictions, and removes harmful content when flagged. They maintain they can't control every piece of user-generated content and have robust safety policies in place. And then there's Prince Harry, not a plaintiff, not a lawyer, but a high-profile advocate who's made children's online safety a personal mission. His presence isn't just symbolic. He's there to amplify voices in a case that could set global precedent. The faces behind the case. Let me share some of the stories that brought families to this courtroom. I want to be clear, these are allegations. The companies dispute that their platforms caused these tragedies. But these families believe social media played a role. One of the parents involved, a mother I'll call Mrs. R to protect privacy, lost her teenage daughter to an eating disorder. She alleges that her daughter, who had been a healthy weight, became obsessed with fitness and weight loss content on Instagram. Despite the family's attempts to monitor her phone usage, the algorithm, they claim, continued serving content about extreme dieting, body transformation, and thinness ideals. Her testimony in court: "We can't make a difference for our children, but we can make a difference for other people's children." That sentence captures everything about this case. These families say they aren't seeking revenge. They're seeking prevention. They don't want other parents to experience what they've endured. The companies respond. Meta points out that they've implemented features specifically designed to limit exposure to repeated diet and fitness content, and that they remove content promoting eating disorders when it's reported. Now, the families point to broader statistics to support their claims. According to the CDC, teen suicide rates increased significantly between 2007 and 2019. Hospital visits for self-harm among teenage girls have risen sharply since 2010. Approximately 1 in 3 teenage girls report seriously considering suicide. The families argue these trends correlate with smartphone and social media adoption. The companies counter that correlation doesn't equal causation, that many factors affect teen mental health, including academic pressure, economic stress, the COVID-19 pandemic, and family dynamics. And here's what makes this even more complex. According to court filings, internal company research did show some concerning data about social media's impact on certain teen users. But the companies argue that they acted on this research by implementing safety features. The research was more nuanced than media reports suggested. Social media also has many positive effects: connection, community, education, support networks. So the question becomes, did these platforms contribute to mental health harm? Or did they simply expose problems that were already there? That's what the trial must determine. Other families in the consolidated case include parents who allege their children encountered dangerous viral challenges on YouTube that led to fatal accidents. Families claiming relentless cyberbullying on platforms contributed to their children's suicides, even after reporting the harassment. Parents arguing that algorithm-driven content recommendations introduced their children to harmful communities and ideas. Each story is unique, but the pattern the families point to is this: vulnerable young people, algorithmic content delivery, tragic outcomes. The companies maintain they've invested billions in safety, employ thousands of content moderators, use AI to detect harmful content, and provide extensive parental controls. They argue that with over 2 billion users globally, they cannot prevent every tragedy, but they take safety seriously and continuously improve their systems. So why is Prince Harry involved? It's personal. Harry has spoken openly about his own mental health struggles, particularly after the death of his mother, Princess Diana. He's described what he calls the feeding frenzy of modern media consumption, how algorithms can prioritize sensational content because it generates engagement. He's also a father now. His children, Archie and Lilibet, will grow up in a world dominated by social media. In previous public statements, Harry has said, "I don't want my children to grow up in a world where their worth is determined by likes and comments." That's why he's here. Whether you agree with his perspective or not, he genuinely believes this case matters for the next generation. The emotional breaking point after the first day of proceedings, something extraordinary happened. Prince Harry wasn't required to address the families. He could have left through a private exit, avoided the cameras, gone back to his hotel. Instead, he stayed. While corporate lawyers were across the hallway preparing motions and legal strategies, Harry stood before approximately 50 grieving parents in a private room. 2 completely different worlds, one built on grief, the other built on legal precision. Witnesses say Harry's demeanor was humble, almost apologetic. He thanked each family for telling your stories over and over again, acknowledging how exhausting it must be to relive their trauma in depositions, media interviews, and courtrooms. He called the case a David versus Goliath situation, which, financially speaking, is accurate. Meta alone has a market value of over $800 billion. These families are regular people facing legal teams that charge thousands per hour. But then came the moment that no one expected. Harry looked at the parents, his eyes visibly welling up, and said, "None of you should be here." His voice cracked. He paused, composed himself. "None of you should have to fight this hard for something so basic." protecting children. Several parents began crying. Some reached out to hold Harry's hand. One mother later described it as the first time someone with a platform truly acknowledged our pain. That moment, that raw, unscripted moment of shared grief, is what separates this from a typical corporate lawsuit. For these families, it's not primarily about money. It's about acknowledgement, accountability, and hopefully change. In our cynical age, it's easy to dismiss celebrity involvement in serious causes, but there was nothing performative about this. The moment happened in private, no cameras, no prepared remarks. It was later shared by attendees because they wanted the world to know someone with influence was listening. And in a case that will ultimately be decided by evidence, precedent, and legal arguments, that human moment of connection reminds us what's actually at stake. Real families, real loss, real pain. The legal battleground. Let's get into the legal details. This is where the case becomes fascinating from a precedent standpoint. The families are pursuing several legal theories. First, product liability. The argument: social media platforms are products that must be reasonably safe for their intended users, including minors. The families allege that Meta and YouTube designed features they knew, or should have known, could be harmful to young users' mental health. Second, failure to warn. The claim that even if the platforms had risks, the companies didn't adequately warn parents or children about potential mental health impacts of prolonged use. Third, negligence. The allegation that these companies had access to research showing potential risks and failed to take reasonable steps to mitigate those risks. Fourth, wrongful death. In cases where children died, families allege the platform's design and algorithms were contributing factors. Here's the revolutionary part. If successful, this case could establish that social media companies have a duty of care to their users, especially minors. That legal standard has never been definitively established in U.S. courts. Meta and YouTube aren't just rolling over. Their defense rests on several powerful arguments. First, Section 230 protection, the nuclear option. This is the big one. Section 230 of the Communications Decency Act says, in essence, online platforms aren't liable for user-generated content. If someone posts something harmful on YouTube, YouTube can't be sued for it. The person who posted it can. Here's the twist. If Section 230 fully applies here, the case could collapse before it even reaches a jury. The companies argue they're protected by this law. But here's the legal crack the families are trying to exploit. Section 230 protects platforms from content liability. But does it protect them from product design liability? In other words, YouTube can't be sued because someone posted a dangerous challenge. That's content. But could YouTube be sued for designing an algorithm that specifically promotes that challenge to vulnerable teenagers? That's product design. That distinction is everything. Second, extensive safety measures. Both Meta and YouTube point to significant investments in safety. Instagram and Meta have teen accounts with automatic restrictions, parental supervision tools, content warnings on sensitive material, time limit reminders, AI systems that detect and remove harmful content, and policies prohibiting content that promotes self-harm or eating disorders. YouTube has age restrictions on content, restricted mode for filtering content, content policies against dangerous challenges, human reviewers and AI detection systems, and parental controls and supervised accounts for minors. Their argument: we're responsible corporate citizens continuously improving our safety features based on research and feedback. Third, shared responsibility. This is controversial but legally relevant. The companies argue that parents ultimately bear responsibility for monitoring their children's online activity, and that they provide tools to help parents do this. They note that account creation requires users to be 13 or older, with parental permission for some features. Parental control tools are available. Warning labels exist on sensitive content. Time management features are built in. Fourth, free speech and innovation concerns. The companies warn that holding platforms legally responsible for how algorithms promote content could lead to over-censorship, stifled innovation, harm to legitimate creators, and violation of First Amendment principles. If platforms fear lawsuits for every algorithm decision, they might remove perfectly harmless content, limit recommendation features entirely, or restrict user expression. Fifth, causation is not proven. Perhaps the strongest defense, the companies argue that the families haven't proven their platforms caused these tragedies. They point out, teen mental health is influenced by many factors including school stress, family issues, genetics, societal pressures, and global events like COVID-19. Many teens use social media without harm. Some research shows positive impacts, community connection, access to support resources, and creative expression. Correlation doesn't equal causation. Both sides have brought in heavy-hitting experts. For the families, there are psychologists specializing in adolescent development and technology's impact on the developing brain, former social media employees who've become industry critics, researchers who study algorithm design and its psychological effects, and medical professionals who can discuss mental health trends. For the companies, there are tech designers who testify about safety considerations in platform development, researchers showing positive aspects of social media, free speech advocates, legal scholars defending Section 230, and mental health experts who emphasize the multifactorial nature of teen mental health. The trial will be a battle of experts. Whoever tells the more compelling evidence-based story will likely win. The global implications. Let's play this out. What happens if the court sides with the families? First, algorithmic transparency requirements. Companies could be forced to reveal more about how their algorithms work, what content gets promoted, what gets suppressed, and why. This would be significant. Right now, these algorithms are largely protected as proprietary information. Second, stronger age verification. Real age verification beyond just clicking "I am over 13." This could involve more robust verification methods, though privacy advocates have concerns about this. Third, algorithm redesign. Platforms might have to modify algorithms to prioritize user well-being alongside engagement metrics. Fourth, independent safety audits. Companies could be required to submit to regular third-party audits of their safety practices. Fifth, legal precedent. This case could open the door for additional lawsuits. If families can successfully sue for alleged social media-related harm, more cases could follow. The legal landscape would fundamentally shift. On the other hand, if Meta and YouTube successfully defend themselves, first, Section 230 remains unchallenged. The legal shield protecting tech companies would be reinforced, making future cases more difficult. Second, self-regulation continues. Companies would remain free to implement safety features at their own pace and discretion. Third, limited legal recourse. Families would have fewer legal avenues to seek accountability for alleged social media-related harm. Fourth, message to lawmakers. A victory for the companies would signal that meaningful regulation must come from Congress, not the courts. And given how slowly Congress moves on tech issues, that could mean years more of debate without major regulatory changes. This case isn't happening in isolation. Around the world, governments are taking action. In the United Kingdom, the Online Safety Act requires platforms to protect children from harmful content or face substantial fines. In the European Union, the Digital Services Act mandates more algorithmic transparency and gives users more control over what they see. In Australia, lawmakers are considering stricter age restrictions for social media access. In Canada, they're introducing legislation addressing online safety for minors. In Europe, platforms are already being forced to change certain practices. In Australia, lawmakers are considering significant restrictions. But in the United States, this courtroom may decide everything. The U.S. has historically taken a lighter regulatory approach to tech companies. This trial could be the catalyst that changes that approach, or it could reinforce the status quo. The uncomfortable truths. Let's address something at the heart of this case. Are social media platforms designed to maximize engagement? The answer is yes. The companies don't dispute this. Engagement is a core business metric for advertising-based platforms. But there's a crucial distinction. Designed for engagement does not equal designed to cause harm. The families argue that maximizing engagement without adequate safeguards can lead to harm. The companies argue that engagement features serve legitimate purposes, connecting people, sharing information, building communities, and that they've implemented safeguards. What do former insiders say? Some former employees have expressed concerns. For example, former Facebook executive Chamath Palihapitiya said in 2017, "The short-term dopamine-driven feedback loops we've created are destroying how society works." Sean Parker, Facebook's founding president, discussed exploiting a vulnerability in human psychology. However, context matters. These statements were made years ago. The speakers no longer work at these companies. Platforms have evolved significantly since then. The companies say they've implemented extensive changes. How do engagement features work? Notifications alert users to new content, keeping them informed. Recommendations help users discover content they might like. Infinite scroll allows seamless content consumption. Likes and comments provide social feedback. Critics argue these features can become problematic without proper guardrails. Defenders argue these are standard features that serve user needs and that companies have added controls like time limits, content warnings, and parental tools. Why is engagement so important? The business model. Meta made approximately $134 billion in revenue in 2023, primarily from advertising. YouTube is one of Google's major revenue sources, also through advertising. The more time users spend on platforms, the more ads they see, the more revenue generated. Critics argue this creates an incentive to maximize time on platform above all else. The companies counter that. They only profit if users find value and keep returning voluntarily. Unhappy or harmed users leave platforms, which hurts business. Long-term success requires user trust and satisfaction. They've invested billions in safety because it's both the right thing and good business. Both perspectives have logic. The question is, which one actually drives decision-making? Here's the really uncomfortable question. What role does personal and parental responsibility play? The companies argue this is fundamentally about parents monitoring children's online activity, users making informed choices, individual responsibility for how we use technology. And there's validity to this. We do hand children smartphones. We do create accounts. We are often distracted by our own screens. But here's the counter-argument from critics. When a product is specifically designed to be highly engaging, using psychological principles studied by teams of behavioral scientists, can we solely blame individuals for struggling to moderate their use? We don't only blame individuals for smoking cigarettes that were engineered to be extra addictive, taking opioids prescribed by doctors when pharmaceutical companies downplayed addiction risks. So why, critics ask, do we solely blame teenagers for excessive use of platforms that employed teams whose job was to maximize engagement? The answer probably lies somewhere in the middle. Personal responsibility matters. Parental oversight matters. But corporate responsibility also matters. The question before the court is, where should the legal line be drawn? Here's something to consider. The same recommendation algorithms that critics say can be problematic are similar to the algorithms that recommended this very video to many of you. YouTube uses engagement signals, watch time, likes, shares, to recommend content. Is that harmful? Helpful? Both. It depends on what's being recommended and to whom. That complexity is exactly what makes this case so difficult and so important. So here we are, back in that Oakland courthouse. Families seeking accountability, companies defending their business models, advocates calling for change, and questions that will help define the digital age. Should social media platforms bear legal responsibility when users, especially young users, are allegedly harmed? Are they neutral tools that people choose how to use? Or are they products that must meet safety standards? Should their algorithms be legally treated differently than their content? The answers to these questions will shape the future of the internet. They will influence whether the next generation grows up in a digital environment with stronger protections, or whether the current model continues unchanged. Prince Harry's voice broke in that private room because he understands something fundamental. Those families believe their children might still be alive under different circumstances. Whether the court agrees remains to be seen. But the only question that matters is, what should the standard be going forward? This case isn't simple. There are legitimate arguments on both sides, families who've suffered unimaginable loss and believe platforms played a role. Companies that say they've invested heavily in safety and shouldn't be held liable for how individuals use their products. Legal questions about free speech, innovation, and where responsibility lies. Only the court can answer the legal questions. But we can all think about the broader questions. What kind of digital environment do we want for the next generation? What role should companies play in protecting young users? Where does personal responsibility end and corporate responsibility begin? Let me know your thoughts in the comments. This isn't about picking sides, it's about understanding what's at stake. Thanks for watching, I'll see you in the next one.